guess you'd like to move on to the next one. This is one out of 103-21. Yeah.
Not here.
Okay, go ahead. Why don't you just go ahead and describe what it is, Clay?
Yeah, you want to see if you can get him, Kelly? You got a chance or not? Or, all right.
Still here.
This is 103-21, a change. Don't know if you want to look at the 103 section or that there. Either one's appropriate. It's an addition to currently the code. Currently, in order to divide property, you have to have road frontage. That is a requirement in Chapter 103. The exclusion is when you're in the ag preservation easement. And the reason for that, there may be logical reasons to put the lot in an area that you can only have 1 acre. And if you tie it up in the in-fee strip, it makes the lot the area where you can put the house much smaller. So when this section of the code was originally created, my understanding, what it had was lot creation from land subject to ag land preservation easement or Maryland Agricultural Land Preservation District. In 2007, the Maryland Ag Land Preservation District agreement was stricken out. The proposal here is to add it back in. In case what you're asking, what is a district, and that's Ralph is I'm going to try to struggle with what the definition of a district is.
It used to be that you had to enter into a district agreement in order to go into the Ag Land Preservation Program, and you then were prevented from subdividing or your land for development purposes for a 5-year period. So you weren't able to do that in a 5-year period, and you had to enter into a district agreement in order to get into the State Ag Land Preservation Program, the MOUNT program.
Okay.
So that was the reason for doing that, and these were basically farms in the on-deck circle, if you will.
And it is my understanding, and
although in some cases they weren't in for 5 years, they were in the minimum of 30 days before they bid their easement. Okay. So if you had to bid your easements in to the state by January or July 1, a lot of people came in and the end of May made a district agreement, and then they were able to bid their farms into the state program.
It's my understanding
and that was the way the state program was from the very inception.
And it's my understanding that there are properties that are still in an Maryland Ag Land Preservation District, have not been accepted into the easement, but they're still in the district. And the county or the state no longer recognizes the ability to put your property into a district anymore?
That's correct.
So, although
the state has done away with it as a requirement, and it's never been a requirement in order to go into the county program.
Okay.
Why did the state do it?
Because they thought it was redundant, it was unnecessary, it was a level of it was a unnecessary step in the process. So that's why it's confusing to me that you want to add something back in that was deemed to be unnecessary and time-consuming into a package like this. When, let's see, agriculture, I think, is still the #1 industry in the county. So I'm confused as to why this would be involved incorporated into this package if it's actually going to be an economic relief.
Why do they want to bring it back?
You want the real answer? The real answer is so that a person that had no road frontage, so they had no subdivision potential, would be able to get children's lots on their ag preservation district property without them going into the ag preservation program. So they could exceed the density at which they were entitled to under our present subdivision regulations. Any questions?
Mr. Ripley.
Very glad to hear Mr. Bale's candid remarks on that. This is referred to on my paper here, if not yours, as the Whitfield Amendment.
Mm-hmm. We have that.
Where's Mr. Whitfield or Mrs. Whitfield? And who is Whitfield? I mean, are we all going to start to submit our own amendments to the code at this point? That stopped in Carroll County government at least 8 years ago that I can recall. So that's my full point on this, if I may.
So your objection is simply to the name? No, I'm just a yes or no.
I do object to it having the name Whitfield.
Okay, I'm aware.
I have wondered where the staff come off from the Whitfield proposal, and as a staff proposal.
Who's Mr. Whitfield? Is he a property owner?
That's correct. And this was forwarded by one of the commissioners. The specific request.
Well, I'm not in
But that's
favor
how
of the
staff
change.
Gets off doing it.
Sorry to use this term.
Anybody in favor of the change?
No.
No. So-
I'm sorry.
The district has been done away with in the state program. One of the things that, well, if you got a week one day, you should sit down with Ralph Robertson. There's been questions raised by commissioners to Ralph about some of the changes or some of the problems with the program, the Ag Preservation Program. Well, come to find out there were problems with the MOUth program. And the county program has eliminated a lot of these obstacles or these problems, and this is one of the things that it's done. The district, I'm not really sure why that was set up like that in the beginning, but the state deemed it to be unnecessary. So we don't need to go back to that district agreement.
Did we get a Y on that, a written Y on that one?
No, you probably did not.
It's unanimous opposition to this.
Okay. Okay, that concludes the 103 and 223, and the ones that are left are the resource